Okay. Since we are live streaming, I will now start recording. Naomi, would you mind recording?
Yeah, just give me 1 second till I start starting. Okay, we are live.
Sorry. Recording? Okay. Welcome everyone to the final round of the Lions Cup Moot for 2022. Congratulations, of course, on making it here to all the competitors. Just as a note, please ensure that you are muted unless you are submitting. Judges, of course, you may keep yourselves unmuted throughout the round. Each speaker will have 14 minutes. Naomi will be giving you time signals at 3 minutes, so when you're at the 11-minute mark, at 1 minute at the 13-minute mark, and then she will verbally and physically show you time at 14 minutes. And you do have that additional 1 minute as per the discretion of our Chief Justice, Mr. Porter. Please ensure that your phone and computer notifications are turned on silent. And as a reminder, please do not inform the judges of the schools that you represent. Your team number and full names are very sufficient. Please note that we may also be taking photos for social media during the round. So there is an individual, it'll either be myself or Naomi, just that is authorized by the 2022 Lions Cup Steering Committee. So unless there are any questions, then we can get underway as soon as the judges are ready.
Okay, well, thank you very much. I think we're ready to start. I understand that Ms. Zhu will be addressing us first on behalf of the appellants. Go ahead, counsel.
Thank you. Good afternoon, justices. My name is Jennifer Zhu, and I'm here today with my co-counsel, Yushin Wu, on behalf of the appellant, Mr. Matthew Stairs, in the case of Barr. The issue before the court today is how to preserve the sanctity and privacy of the home during law enforcement operations. Would the court require a brief summary of the facts?
No, I don't think we need a summary of the facts.
It is the appellant's position that the Supreme Court of Canada erred in finding that the search performed in Mr. Stairs' home did not infringe on his Section 8 charter rights. And to this end, the appellant has 3 submissions to make. I will address the first, and my co-counsel will address the final 2. Our first submission is that the modified framework requiring the presence of an imminent safety threat to perform a search legitimately is the correct one to use. And our second submission is that when the facts of the case are applied to this framework, the safety search was not justified. Our final submission will be that the evidence ought to be excluded under Section 24(2) of the Charter. In light of these submissions, we respectfully request that the Supreme Court of Lions Cup allow this appeal and overturn the decision of the lower court. To begin with our first submission, it is the appellant's position that the framework used by the majority to assess the validity of a search incident to arrest, which only requires a reasonable basis for a safety risk, sets too low a bar, and that rather, for a search in an arrestee's house to be justified, it is our submission that the bar should rise to the level of reasonable suspicion of imminent safety threat to the police or the public. I would like to begin by laying out 2 principles that are fundamental to our legal system. First, that there is an exceptionally high expectation of privacy within an individual's home. In the 1995 Supreme Court of Canada case of the Queen and Silvera, the court found that there is no place on earth where persons could have a greater expectation of privacy than within their dwelling house, and continue to find that the high weight placed on a person's security in their home affords the individual a measure of privacy and tranquility against the overwhelming power of the state. Secondly, warrants serve as a cornerstone of due process and provide a fundamental and necessary check on police and state power. In the 1984 Supreme Court of Canada case of Hunter and Southern Inc., the court found that the warrant requirement puts the onus on the state to demonstrate the superiority of its interest to that of the individual, and serves as a means of preventing unjustified searches before they happen. Further, in the case of Hunter, the court found that prior authorization, where feasible, is a precondition for a valid search and seizure, and it follows that warrantless searches are prima facie unreasonable under Section 8. The party seeking to justify a warrantless search bears the onus of rebutting the presumption of unreasonableness. This precedent set in Hunter. Yes, Justice.
Is the distinction that you're flagging for us in what you're proposing essentially the difference between an imminent safety risk and a safety risk as the Supreme Court laid out?
Yes, that is correct.
And so I'm assuming that in your submissions, you're going to clarify for us the difference or distinction between an imminent safety risk and a mere safety risk?
Yes, Justice.
Okay, and so you can do that now, or if you were planning to address it in your submissions, then you can continue with your submissions.
Yes, thank you, Justice. The precedent indicates essentially that warrants should be taken as a requirement for a legal search, and only when it is ultimately impossible for a police officer to obtain a warrant can a safety search be performed. And as such, the threshold required to be met in order for police to search a home without a warrant must be set higher in exigent circumstances. In other words, there must be a reasonable suspicion of an imminent threat to police or public safety. In paragraph 125 of the case at bar, the dissent clarifies why imminence is a good bar, stating that imminence is a useful concept in this instance because it defines those circumstances where obtaining a warrant is not feasible, and it signals that if police can get a warrant before searching a home, they should do so. In section 478 of the Criminal Code, it is indeed stated.
So why wasn't it, counsel? Why wasn't it feasible to get a warrant in this case? Why do we set the bar that high? Is there not a public safety issue in the context of these facts that the police were addressing? Mr. Stairs was known to be violent, was he not?
Yes, Justice. Mr. Stairs was known to be violent, but when Officer Vandervelde performed the safety search in Mr. Stairs' home, Mr. Stairs had already been handcuffed and placed into custody, and as such, the safety threat that existed in the house had already been essentially neutralized. And because of this, Officer Vandervelde had the opportunity to obtain a warrant to search the home before he performed the safety search. And because he had the time and the ability to seek a warrant.
But how was the safety risk neutralized by the arrest? I mean, he fled down into the basement and they went to get him and then they arrested him. And surely they can look around in the basement to see if there's anything that might be of any threat to them. I mean, the officers were concerned for their own safety. At least that was the evidence at trial, wasn't it?
Respectfully, Justice, we disagree. And in Officer Vandervelde's testimony, he explicitly states, in fact, in paragraph 145 of the case of bar, that only once Mr. Stairs was in handcuffs.
Can I just ask you to slow down? It's hard to take notes at this Speedy Gonzalez speed that you've got here.
My apologies. Yes, Justice. But Officer Vandervelde had stated, quote, "Once he was in handcuffs and I felt it was safe, I proceeded through the basement to make sure there was no other obvious threats or other people in that basement. We never really know exactly what you're looking for when you're entering a house in a situation like this. So whether there's firearms sitting out, like I said, other people that could be in the basement." And this testimony essentially indicates that Officer Vandervelde had neutralized the imminent safety threat.
I think, counsel, he's indicating he was safe from Mr. Stairs. He's not indicating that there were no other threats in the room, is he? He then goes on to say he proceeded to make sure that there were no other obvious threats or any other people in the basement.
Yes, Justice. Officer Vandervelde was indeed ensuring that there were no other safety threats, but it is our position that when doing such searches where there is no imminent safety threat, Officer Vandervelde must first secure a warrant before clearing the basement. And
but how realistic is that, really? I mean, so we know from the majority decision in the Supreme Court of Canada, and this is sort of common sense, that police won't have intelligence about every single threat that may be sitting in a home. They may have no idea that there's another person there. They may have no idea that Stairs has connections to sort of other people there that may be violent, that may want to sort of neutralize the police. What you're saying is the police need to have that information in advance before they can sweep the room to be sure that there are no other threats. And isn't that just unnecessarily heightening the risk to police?
No, Justice. And I would like to answer your question in two parts. First, that the facts of the case reveal that when police received the 911 call, there were no weapons mentioned in the dispatch itself. And secondly, that
but my point isn't these facts particularly. My point is that police may often not have intelligence. And why should we require that they have that information in order to do a safety search when, as the Supreme Court noted, the police often have to expect the unexpected? Like we would just say because he didn't have the information, it's okay if an officer gets shot? No,
Justice. It is our position that in alignment with existing precedent in the 1998 Supreme Court of Canada case of the Queen and Caslake, the court found that an arrest that only gives rise to safety concerns cannot without more authorize a search for matters unrelated to safety, and that officers cannot rely on the fact that objectively a legitimate purpose for the search could have existed when that is not the purpose for which they searched. And indeed, the arrest that was performed on Mr. Stairs was primarily a safety arrest. And once Mr. Stairs had been apprehended, the primary purpose of the arrest had been fulfilled. And the search, as was stated by Officer Vanderbilt himself, was simply to ensure that there was no other threats present at the time. And
but that is a safety purpose for the search. The quote that you just provided is suggesting that it couldn't have been for other purposes, but the purpose stated was for safety.
Justice, respectfully, we disagree with this framing of the facts, because once again, it is our position that in order for a safety risk to exist to such an extent that it justifies a warrantless search, there must be an imminent threat to safety. And indeed, when police entered Mr. Stairs' home and arrested him, Mr. Stairs did pose an imminent risk. But once he had been apprehended, that risk no longer existed. And any further search that was performed, as Officer Vanderbilt did indeed perform, of the house was an additional layer of security for which Officer Vanderbilt could have and should have obtained a warrant.
Aren't we sort of splitting hairs then on this weight of the word imminent? I mean, let's just be hypothetical here. What would facts be to ask you that would turn this into imminent? I mean, let's just talk it out here. What you say this is not, imminent, and imminent is what the main purpose of all of this is about. What would make it imminent? What fact would you suggest that would bring this into a notion of imminence?
Certainly, Justice. I'd like to answer your question in two parts. First, in the 1997 Supreme Court of Canada case of the Queen and Feeney, the court specifies that exigent circumstances, which can be taken to be synonymous to imminence, arise usually where immediate action is required for the safety of the police or to secure and protect evidence of a crime. And secondly, to another example of imminence, there is the case of the Queen and MacDonald. And the facts of that case are an example of when an imminent safety harm allowed police to enter Mr. MacDonald's home without a warrant. In that case, when police knocked on Mr. MacDonald's door, they noticed that he was hiding something behind his leg, and he refused to show police what it was. So they broke into his home without a warrant and later discovered that indeed he had been harboring a weapon. And in this case, the court found that this break-in essentially, or this warrantless search or warrantless entry into the home was justified because at the time, police were experiencing an immediate danger. They didn't know what Mr. MacDonald had behind his leg. And indeed, had they not entered, they could have been another safety risk because he was indeed carrying a gun.
So I asked you an example on the case in this case, but you gave me two examples from other cases. What in this case, in your case, in a situation of Mr. Stairs, where you say this is not imminent within the confines of imminent, what would be elevated to make this now an imminent situation? What would it do? What would it need for you to be to say, well, maybe this is now an imminent situation in the facts of this case?
Justice, a potential hypothetical that could arise is had the police gone downstairs and noticed a weapon lying out in the open before Mr. Stairs had been apprehended, that could have potentially grounded the ability for police to further search the area to ensure that there were no weapons there because they knew there were other people in the house. But essentially, when police entered Mr. Stairs' home, the information they had indicated that Mr. Stairs was unarmed and that the only safety threat essentially which existed in the house was Mr. Stairs himself. As such, once this imminent threat had been neutralized by the arrest of Mr. Stairs, police had no further authority with which they could have searched the area that Mr. Stairs had been in, especially the area adjacent to where he had been.
So are you essentially arguing that it should not be lawful for police officers to conduct searches incident to arrest in a home once the person's been arrested? Sounds like that's where your argument is going.
No, Justice, we're not arguing that. What we are submitting is that searches incident to arrest are unlawful when they are performed under conditions where officers could have otherwise obtained a warrant and did not, which is the case in this case, where officers, in order to search the home, could have obtained a warrant because there was no imminent safety threat and chose to perform the search without a warrant. and thus making it unlawful and breaching Mr. Stairs' Section 8 charter rights.
What's the nature of the information that you think the police should have in order to justify a search incident to arrest inside a home? For example, could it be the nature of the home that they're entering? Let's say it's a known drug trafficking location. Would that be enough, or does it have to be individual specific?
Justice, there are many instances under which safety searches may or may not be justified. I would, if you were asking for a hypothetical under which potentially if it was a drug den, then could they be satisfied? Perhaps police could have obtained a warrant beforehand, knowing that there was a likelihood of drugs being there. But I see my time has nearly elapsed. If I have a brief moment to finish answering your question and concluding.
Sure.
But in this case, the bare fact remains that when police were going to make the arrest, they were not aware of the possibility of drugs. They were not aware of the possibility of weapons. They were responding on a domestic violence call, thus meaning that the only purpose that they were at the house to fulfill was to apprehend Mr. Stairs and ensure that the victim and any other potential members of the public were safe. And as such, once this arrest had been conducted and Mr. Stairs was in custody, the purpose of the arrest had been fulfilled, and any further searches in Mr. Stairs' home were thus unjustly conducted because Mr. Stairs had been apprehended and police could have at that time obtained a warrant. Barring any further questions, this concludes the first submission on behalf of the appellant. My co-counsel will now address the second and third submissions.
May I proceed?
Yes, counsel, go ahead.
Good afternoon, Honorable Justices of the Supreme Court of Lions Cup. My name is Yushin Wu, and I will be completing the second and third submission on behalf of the appellant, Mr. Stairs, in the case at bar. It is the appellant's position that the application of the facts of the arrest demonstrates that the search conducted by the police infringed upon Mr. Stairs' Section 8 charter rights. As such, the evidence should also be excluded pursuant of Section 24, subsection 2 of the Charter. Section 8 of the Charter confers the right to be secure against unreasonable search and seizure. The scope or extent of this right is to be determined by balancing the privacy interest of an individual with legitimate law enforcement objectives. And this balance is struck when police are only authorized to conduct a search incident to arrest inside a home when there is, one, reasonable suspicion, and two, that there is also an imminent threat to the safety of the police or the public. The search incident to arrest conducted by the police in the case at bar does not meet the standard for the subjective grounds for reasonable suspicion. When assessing the reasonableness of a police search, only the subjective grounds for the search may be considered, as noted in the 1998 Supreme Court of Canada case of the Crown and Class. The court cannot rely on the fact that objectively a legitimate reason for the search existed when that is not the purpose for which they searched. The facts and evidence of the search conducted by the police must be examined to determine the subjective basis for such a search. Officer Vandevelde testified that the search was conducted only after Mr. Stairs was in handcuffs and that he felt it was safe to continue. When questioned further about the importance of the search, Officer Vandevelde justified it by stating that you never really know what kind of hazards could be down there. You never really know. That is the justification the officer gave after conducting an unlawful search of Mr. Stairs' home. This is simply not a constitutionally acceptable reason for police to search a private home where our most intimate and private activities are most likely to take place. The heightened privacy interests present within Mr. Stairs' home were violated by the police's subjectively unreasonable search.
But counsel, isn't it because of those heightened privacy interests and the most intimate type of actions that occur in the homes that domestic violence also occurs in that context?
Justice, we do sympathize that due to the nature of domestic violence cases, often being the home often shielding the victim from, my apologies, we acknowledge that for victims of domestic abuse, that the home is a place that shields and enables their abuse. However, it is not just the autonomy of the victim that we're concerned about, but also that of Mr. Stairs. And this balance between these privacy interests are best struck when the police can conduct a search only when there is reasonable suspicion that there's an imminent threat to the safety of these parties.
Counsel, didn't Mr. Stairs essentially waive some of those rights to not have his parts of his home searched when he was arrested for such a serious offense? And if the police have objective evidence, which the trial court found they did, is that not enough? Because you're taking the position that, well, this was an illegal search, but that's up for this court to decide, is it not?
Justice, I would like to answer your question in two parts. First, the trial judge's finding was based on applying the unmodified framework, which is not the one that we are proposing here today. Secondly, although Mr. Stairs' rights of privacy would not be as elevated due to the arrest, it still nonetheless needs to be respected and balanced accordingly, because the privacy rights within a home are at the most heightened level and is the foundation for the protection granted by Section 8.
But I think we can agree that the privacy rights are not absolute in this circumstance. There is a test that needs to be applied. Is that not right? Because you seem to be taking the position of this is a zero-sum game.
No, Justice, we are not suggesting that Section 8 be a blind protection of all individual privacy interests. However, due to the nature of the search conducted by the police not being either subjectively or not being subjectively justified, that the search infringed upon Mr. Stairs' Section 8 rights.
Well, what's the nature of the subjective test that you're advancing here? Are you saying, I guess, asked your colleague this, what kind of information does a police officer have to have? And is that a bit unrealistic? I mean, they deal with all kinds of dangerous situations all the time, and they won't have necessarily complete information. Do we say, well, that's just too bad, police officer, your life is going to be on the line, and if you get shot, that's just too bad, our Constitution allocates for that? Is that your position?
No, Justice, that is not our position. We are privy to the fact that
police... Take Stairs, for example. Take this brief, for example. They go down, and let's say they do what you say they ought to have done. Arrest them and take them out. On the way out, somebody from the basement comes up from behind the couch and shoots them. You would say, fine.
Justice, the hypothetical that you are providing here and the generalized uncertainty about potential risk factors exists in many arrest scenarios. However, without sufficiently particularized evidence, a mere hunch or a mere expectation that there could be a risk is insufficient to ground reasonable suspicion. And
but why should it be unreasonable where we're dealing with volatile situations? We've got an arrest, which can be violent. A takedown can be violent. The police won't have, they're operating often with incomplete information. Why is it unreasonable to allow at least some modicum of safety search? And it might be, we may disagree on the scope of the search, but the fact of allowing the search, why is that not a proper trade-off given the nature of crimes that are investigated?
Justice, to answer your question, may I point you to the 2013 Supreme Court of Canada case, the Crown and Cahill. In paragraph 47, it says that an officer's educated guess cannot supplant the rigorous and independent scrutiny demanded by the reasonable suspicion standard. What we are not suggesting that the privacy interests of an individual comes before that of the safety of the officer, but rather the standard that we are proposing is to ensure the best balance between such privacy interests and the safety interests of the officers is met. And hence why we require that there be a reasonable suspicion for an imminent threat, which was not present here, as Mr. Stairs was already apprehended, and anything beyond that would just be a mere hunch or intuition by the officer, and without the sufficiently particularized evidence that is lacking in this case, the officers cannot reasonably justify the search.
Well, isn't it more than when you talk about educated or uneducated guesses and hunches, that they are aware that not just another tenant, but this individual's father, who may have an interest in his son not getting arrested and taken by the police, is living in that home. And so there's a very potentially interested party. And as my colleague, Chief Justice, indicated, would it be then, well, then they should have been able to look because they're walking up the stairs and daddy comes up and shoots him. And so, I mean, that's why I asked your colleague about sort of what would rise this in your notion of this word imminent to imminent. I mean, we're talking about giving the police some breadth of power to ensure sort of nearby safe spaces in searches incident to arrest. How do the facts in your case separate it such that an officer can't just go to the room where the individual had come by to take a look? Isn't that really all that we're talking about? How do you say you can't even go and look into another room? Where does it come to for the police's ability to then make sure that there is a nearby safe space as the officers are continuing to do their duties?
Justice, to answer your question, and since you asked me to apply the facts of the case, I must point out to you that Officer Brown testified that he had no observation from the scene that anyone was in danger. The officers also visually inspected the basement upon first entry prior to arresting Mr. Stairs and felt it safe enough to focus on him. And Officer Vandervelde again stated that he felt it was safe to proceed with the search.
I mean, but counsel, how can you say that brief scan as they wander through the basement because they're pursuing the obvious immediate threat then somehow is enough that they can't look further once they've neutralized the immediate threat? That doesn't mean there's nothing else.
Justice, well, that is true. If I may point to paragraph 16 of the case at bar, in which it was stated that after the arrest, Officer Vandervelde conducted a visual clearing search of the adjoining living room and found nothing of note. He couldn't see what was behind the couch, so therefore he had to walk behind the couch, and that was where the evidence
Because
was
there
found.
could have been somebody with a gun hiding behind the couch.
Justice, it is our position that the officer conducting the first visual scan prior to entry and then the one that was done after the arrest is sufficient. And if no potential safety risks were found in either of these two, that it is reasonable and feasible for the officers to obtain a warrant, but before further encroaching on Mr. Stairs' private home.
But just a second, you're saying that when they're downstairs in the basement and he does this visual scan, let's call the visual scan a search. Would you agree with that?
Yes.
Okay, so that's not authorized by warrant. You agree with that?
Yes.
All right. So you say the visual scan search is okay, correct? Constitutionally sound.
Justice, it is our position that the search that the visual scan conducted prior to the arrest was constitutionally sound, as it was simply part of the police's process. However, the one that was conducted afterwards was not constitutionally sound. And that, combined with the fact that the officer encroached further, infringed upon Mr. Stairs' Section 8 rights.
But okay, so you're saying
Sorry, go ahead. Sorry, go ahead, Nicole. Go ahead.
so you're saying that just by standing at the door, which they had to be at anyways, and looking into the room, that's not constitutionally sound?
No, it was the search conducted and the intent behind the search.
But you said a moment ago that the subsequent scan of the room before they then went further into the room was not constitutionally sound.
To answer your question, it is more of the intention behind the search, the fact that they came into Mr. Stairs' home to arrest Mr. Stairs, and after he had been apprehended, there was no more immediate threat.
But so they're supposed to close their eyes once they've arrested him?
No, Justice, that is not what we are suggesting at all. However, it is merely the intention. The facts.
But let me ask you this. Let's say, following on my colleague's question, let's say they arrest him. And as they arrest him, they look around the room and they see the drugs. What then? Can they take them? Can they seize them? Is that improper search? Was that visual inspection constitutionally unsound? are they required to sort of have some other information to allow them to look around the room?
Justice, I think what you were suggesting is that we apply the plain view doctrine. However, there's no need to consider that, as the Tupperware container was not in view and was in fact behind the couch. And the lower court had raised this question twice and were not addressed either time. To quickly go into my last submission, it is the appellant's position that the evidence ought to be excluded under Section 24, subsection 2 of the Charter. In the 2009 Supreme Court of Canada case of the Crown and Grant, the court identified 3 factors to guide whether the admission of justice tainted by a charter breach such as this one will bring the administration of justice into disrepute. I see that my time is nearly elapsed. May I request a brief indulgence to conclude my submission?
Yes, sure, go ahead.
The first of these grant factors is the seriousness of the charter infringing state conduct and falls in the higher end of culpability, and as such strongly favors the exclusion of evidence, alongside the second grant factor also heavily favoring exclusion due to the severe impact on the breach of Mr. Stairs' Section 8 charter rights.
Counsel, how can you say
Go ahead. Sorry, no, go ahead.
how can you say that the state infringing conduct was on the higher end here when there's a factual finding below that they were acting in good faith in an uncertain area of law?
Justice, well, the officers cannot be taken into have been acting in good faith, as they did not conduct themselves in a way that they thought was in accordance of the law.
But we have a factual finding that they were acting in good faith. Are we supposed to ignore that?
Justice, it is the appellant's position that the characterization made by the trial judge is not correct, and that there was in fact
Well, I mean, that may be your submission, but we're not a trial court. We're not going to review that. So tell us something else other than saying reverse a finding of fact.
Justice, it is the role of this court to apply the standards of reasonable suspicion in light of the specific evidence, with an emphasis on the actual reasons why the officers justified the search that was conducted.
I just want to ask, I know your time is limited, but I just want to unpack really quickly. You said it was a severe violation of his rights. Why is it severe? They just looked behind the couch, or was it in front? I can't remember now. But they didn't go upstairs, rummage through the entire house, go through every single bedroom, like in Gollop, lift over the mattress, go through all the drawers. That didn't happen here. That might be characterized as severe. Why is this severe?
Justice, an unlawful warrantless residential search violates the privacy interest that lies at the core of Section 8, as I pointed out to earlier, and the requirement of a warrant is one of the cornerstones to keep police and state powers in check.
Yes, I understand that. But what I'm trying to get at is what the police did here, you've characterized as severe, and I want to sort of stress test that position. There are degrees in which police violate rights. They may cross over here, but it may not have been as severe as, say, in Gollop or other cases.
Justice, in the lower court, in the Crown and Grant, it explicitly stated that an unreasonable search that intrudes on an area that an individual reasonably expects a high level of privacy is more serious than one that does not. The search of Mr. Stairs' basement falls squarely in line with this characterization, and as such, it is the appellant's position that it falls in the higher end of the spectrum of culpability. In conclusion, it is the appellant's position that the search conducted by the police violated Mr. Stairs' Section 8 rights, and the evidence ought to be excluded under Section 24, subsection 2 of the Charter. As such, we urge the Supreme Court of Lions Cup to allow the appeal and overturn the lower court's decision. Thank you.
Thank you. Yes, counsel, go ahead.
Perfect, thank you. Good afternoon, Honorable Justice of the Court. My name is Palacios, first initial M, and I am accompanied by my co-counsel, Eladina, initial S. Before I begin, I would first like to acknowledge and give respect to the land on which I present today, the territory of the Haudenosaunee. We rise on behalf of the respondent, Her Majesty the Queen, in the case at bar. The respondent requests that the Supreme Court of Lions Cup dismiss the appeal and uphold the lower court's ruling. The respondent has 3 submissions to make before the court today. Our first submission is that the modified standard proposed by the lower court is appropriate for residential searches incident to arrest. Our second submission is that the reasons for safety search were sufficiently justified. And our final submission, is that should the court find that the search be unreasonable, the evidence should be excluded under section 24, subsection 2 of the charter. I will be addressing the first submission today, and my co-counsel will address the following 2. Beginning with our first submission, the warrant requirement is a foundational check on police powers and a cornerstone of Canada's constitutional order. Although some exceptions do exist, including the common law power of search incident to arrest, the accused's privacy interests inside a home were significant, and the unlawful searches and seizures. Oh, sorry, I'm so sorry. I seem to have. I'm so sorry, guys. I seem to have messed up. Can I start over?
It appears that you may be arguing
Yeah, you're arguing.
half of your
Unfortunately, I do seem to have pulled up.
opposing counsel.
Yes, the opposite one. May I start over? I'm so sorry.
Yes. Well, just start. Yes.
I'll pick up from where I left off with the submissions. While privacy interests in a home are significant, so too are the interests in protecting police and public safety. Police must be able to address the hazards that may arise in unfamiliar and potentially hostile environments, especially when investigating serious offenses such as domestic violence. Weighing the privacy law enforcement interest under Section 8, the balance is best struck by authorizing to conduct a search incident to arrest inside a home when they reasonably suspect that there is a threat to safety of the police or the public. The common law standard permits the police to search a lawfully arrested person and to seize anything in their possession or the surrounding area of the arrest to guarantee the safety of the police, the arrested person, prevent the person's escape, or provide evidence against them. The police in our position had reason to suspect that there was a safety risk in the basement living room and that their concerns would be addressed by a quick scan of the area, which was in the least intrusive manner possible in these circumstances. It follows that the
What was the reason to suspect that there was a safety risk in the basement? Simply because he fled to the basement?
Thank you. The officers had a reasonable suspicion that there could be other weapons or hazards present among the area that they were in.
And what was the
Sure,
basis of that?
Yeah.
Pardon?
What was the basis of suspecting the presence of weapons?
In the situation at hand, when the arrest took place, it was due to a domestic violence case. And when they looked back at the prior cautions that Mr. Stairs had, it was only safe to not assume anything and to look before proceeding with anything else.
No, but that's different than suspecting that there were weapons, as my colleague just asked you. Well, was there evidence that they suspected there was weapons?
In the case, Mr. Stairs was a high-risk offender. So, and by looking at it, they were only ensuring the safety of themselves and other people within the area.
But counsel, didn't the police have him in custody at that point?
Yes, the accused was already in custody, but apart from, as I previously mentioned, it was a domestic violence case. We don't know exactly what he may have domestically.
Okay, but if there were weapons, unless there was explosives, what harm would any weapons cause? And if there's reasons to believe that there's weapons, then you can ask a justice for a warrant at that point, can you not?
They were only doing a cursory search in this matter. They weren't necessarily searching or digging for anything. They were just seeing if there was anything laying on top that could be of any harm to absolutely anybody, whether it was the victim.
You're not telling me where this harm is coming from with your accused in custody.
From the prior cautions that he had.
But he's in custody. Was he going to jump out of the handcuffs, go into the next room, grab a pair of nunchucks, and assault the police?
No, he wouldn't necessarily do that, but somebody else might. Somebody else.
Yeah.
The father also lived within the home. He could have been around the area, hiding around the corner, behind the couch. He could have been anywhere.
Does the father have a history of violence and he could jump out from behind the couch? I'm not trying to be funny, but where is the objective evidence here?
In this situation, one truly never knows what to expect when entering a home where there are already prior cautions set. So it's important that the police be aware of anything that can possibly come
So
up.
is the standard then one truly never knows, and the police can just simply say that to authorize whatever search they wish to do past arrest?
In the situation that took place, when the officers entered the home, they noticed that the appellant ran from one side of the area to the other. So it only made sense that after he was arrested to see what was in the other room, which he ran from.
But on your point about the father, I mean, I thought the police had, so the police noticed there was no signs of another person other than the victim or Mr. Stairs. I mean, the father lived at the home, but there was no sign of him at all.
Additionally, Justice, in response to your question, the officers before entering the home, they also called out asking if anybody was present, to which there was no answer. So they couldn't really trust who was home, who was there, or what was necessarily going on.
But they never saw signs of any people aside from Stairs and the victim.
But they never heard anybody either once they called out. So how they couldn't trust, regardless whether there was a suspicion or not of another person being in the home. They called out, there was no answer. They had to use what they could to ensure that everybody was safe and located.
But on that theory, you would authorize a search of the entire house.
Justice, not necessarily in the situation, because their main concern was ensuring that that specific area was not reachable to anybody, or that there wouldn't be any harm to the police officers that were there. Nobody was upstairs.
So following Justice Goodman's questions, Dad would have only been behind the couch. Is that your point?
The father could have been anywhere within the home, but it was the fact that he wasn't in the physical area of control where the appellant was, nor the officers. A search incident home to arrest complies with Section 8 of the Charter when the following requirements are met. Firstly, that the arrest was lawful. Secondly, that the search was incident to arrest. And thirdly, that where the area is outside the arrested person's physical control at the time of the arrest, but still within the area sufficiently proximate to the arrest. As the baseline common law standard for search incident to arrest requires, that the individual searched has been lawfully arrested, and that the search is truly incidental in the sense that it is for valid law enforcement purposes connected to the arrest, and that the search is conducted reasonably. Since in this present case, the police believe there was a safety risk that would be addressed by conducting a clearing search of not only the laundry room, but of the living room after the arrest had taken place only moments before, to which Mr. Stairs had emerged from.
I'm just having a hard time understanding how it's reasonable to suspect that there's a risk in the living room based on the information that the police have. How is it reasonable to suspect there's a risk?
Due to his prior cautions that he had on him.
They've got him, as Justice Goodman said, they've got him. He's arrested.
Yes, he is arrested, but as I mentioned before, he did also, due to these prior cautions, it might have been another risk lying around. Somebody else, or maybe one of his friends could have been.
I guess my concern is that might have been. I guess that's the point where where I want to interrogate or better understand is from a constitutional law perspective, should we not, and this is someone's home, should we be providing the police with the ability to conduct a search incident to arrest, the scope of which is defined by their might have been understanding of a risk? Don't we want something more precise, particular, objectively discernible than something that is might have been?
In these hypothetical positions, it would be wrong to ignore the realities of the situations in which police officers must make these decisions. They took the decision that they felt was best approachable.
Okay, so let's talk about the reality of this situation. Mr. Stairs is the threat. Mr. Stairs is no longer a threat. So what is the purpose of continuing to search the room as though there still remains a threat? And again, we can't simply allow searches to expand exponentially simply because the police believe there's a risk.
We're not necessarily saying that there has to be a specific threat. There just has to be the probability of a threat. Any threat in the immediate surroundings can be a risk, which is why the officers acted the way they did and did this cursory search.
And why is the imminent threat standard that's being proposed by your friends not the right standard here?
The officer who concluded the clearing search testified that the search was performed in order to ensure that nobody was there and that somebody that was potentially posing a risk or needing assistance was there in regards to there being no other hazards, such as weapons or firearms out in the open.
So you're submitting that that is an imminent risk? Is that?
No, we're submitting that there could have been a probability of a risk. So the officers went on and about looking for this possible risk.
But I don't think you fully answered Justice Bashi's question. Why shouldn't there be an imminence requirement? Aside from whether there was imminence in this case, why shouldn't we impose an imminency requirement?
As I previously stated, it's the probability of a possible threat that could arise in any situation, such as domestic violence. It's appropriate for the police officers to go on and about and look for anything that can possibly, as I've mentioned many times before, harm the police, the accused, or the victim further.
But isn't this going to be the case in every single arrest in a house? In every single arrest in a house, the police officer is going to say, well, I don't know, there could have been somebody hiding behind the couch, or there could have been somebody somewhere. I mean, isn't your argument essentially to condone warrantless searches of a house always incident to arrest? Because that's necessary for officer safety, because it might have been, could have been possible.
In the situation that took place, it was rapidly changing, and the arrest was for a domestic assault. I
want to elevate this out of the weeds of these facts for a moment, and I want to understand as a matter of doctrine. Right? When would the police not be allowed to search like this? They've arrested the person. When would they not be allowed in your doctrinal analysis? When would they not be allowed to search the house or the areas of a house for officer safety?
In the situation when they entered the home, they immediately noticed that the accused and that the victim were in the basement, which is why they headed there in the first place. Other than that, they had no reasonable suspicion that there were any other people or weapons outside of that area, and it would be unconstitutional to the case at bar.
If they went outside that area?
Yes.
So had they searched rooms upstairs, you would agree that that would be unconstitutional?
Yes, because they were only worried about the physical area that they had.
Right. And does there not need to be some information to inform their understanding of the risk of the physical area beyond a hunch?
The hunch that they had and the reasonable suspicion that they had was that came from the cautions that the appellant previously had on him. Additionally,
what is it about the cautions that makes it reasonable?
That he was a high-risk offender.
Okay, meaning what?
That he could possibly reoffend again, and that he could
but to Justice Goodman's point, it's and my colleague Justice Barclay as well. He was the problem. It's not like he was part of a gang.
Of course.
Or organized crime.
We wouldn't know that necessarily, though. We wouldn't know what other affiliations he might have had, especially after the methamphetamine was found. And it could have been for the purpose of trafficking. At the same time, it was 90 grams that was found. I don't think he was doing 90 grams.
But that's later on. We're talking about at the time of the search.
Of course. And in regards to the search, they were doing the cursory search to ensure that there were no other hazards. And by doing so, they were able to find a possible hazard that ended up.
How was the methamphetamine posing a hazard to them?
Not necessarily. Oh, I noticed that my time is done. May I have a brief moment just to answer your question?
Yes, absolutely. Please answer that question.
In regards to the drugs that were found, their main purpose was to ensure that everybody that there was no other hazards around. And by finding that drug, it was simply just in plain view, and they were able to seize it. They were able to seize it because it could have posed a threat to him prior to him being arrested. Thank you.
Sorry, I'm not sure that answers the question. The drugs are just sitting there. They're not attacking anybody. They're just a thing. What's the risk that they pose?
Correct. The drugs were just sitting there, but the accused could have taken them previous to the domestic violence that took place. And they could have also not really lots of drugs in the first place. So just having them there constitutes as enough evidence to bring forward afterwards. And I notice my time is up again. I'll pass it over to my co-counsel, barring any further questions.
Thank you. Thank you.
Am I okay to go, justices?
Yes.
Thank you. Good afternoon, honorable justices of the court. My name is Alidina initial S, and I rise to conclude submissions on behalf of the respondent, Her Majesty the Queen, in the case at bar. Before I begin, I would like to first acknowledge and give respect to the lands on which I present today, including the territories of the Anishinaabeg Nations and the Haudenosaunee Confederacy. The respondent's second submission today is that the reasons for the safety search were sufficiently justified. And our final submission is that a section 24 subsection 2 analysis, if conducted, would favor the admission of the evidence without bringing the administration of justice into disrepute. Before I proceed with my submissions, however, I would like to address those of our friends. First, our friends have made a reference to paragraph 145, saying that once Mr. Stairs was in handcuffs and felt he was, and quoting Officer Vanderbilt, saying that he, quote, felt it was safe. I would like to refer your honorable justices to paragraph 85 of the case at bar, where it's noted that the officer who conducted the clearing search testified that the search was only performed to ensure that, quote, no one else was there, such as someone potentially posing a risk or needing assistance, and that there were, quote, no other hazards, like weapons or firearms sitting out in the open. Secondly, our friends have posited that the officers in the case at bar could have simply proceeded with a warrant. We cannot lose, I urge this court to recognize that we cannot lose sight of the fact that the officers were acting within an information vacuum. They've gone into this residence armed with just a handful of pieces of knowledge about this assault. The victim is not cooperative, and the police officers do not know who the occupants are in this residence. They don't know if there are other individuals in the residence, and they don't know if individuals have been injured. And these are the same circumstances that the court saw in Godoy. Furthermore, our friends cited Caslake at paragraph 27, or my apologies. Our friends have mentioned that maintained that the police acted on generalized suspicion as opposed to reasonable suspicion. With respect, we would disagree. I would refer your honorable justices to paragraph 96 of the case at bar and recognize that in assessing whether the conduct of the police was objectively reasonable in the circumstances of this case, we must look to Justice Doherty's insight in Golub at page 757. In volatile circumstances where the police must expect the unexpected, it is, quote, wrong to ignore the realities of the situations in which police must make these decisions. Even though it's critical that the line between generalized suspicion and reasonable suspicion must be maintained, in cases like the one at bar, we must assiduously avoid using 2020 hindsight as the yardstick against which to maintain instantaneous decisions made by the police.
Counsel,
Go ahead. Sorry.
what was so volatile about the situation? As my colleagues on the court have stated, Mr. Stairs was already under arrest. And so what was the risk or the aspect of the situation that, would have maybe been unclear to police, possibly raising safety risks?
Justice, I would refer you to both paragraph 90 and 94 of the case at bar. In first paragraph 90, in domestic violence cases, police are not only concerned with the privacy and autonomy of the person arrested, but they must also be alert to the safety of all members of the household, including both known and potential victims. Referring you now to paragraph 94, police in the case at bar could not depend on the victim for reliable information about the presence of other people, hazards, or even the cause of her own injuries. And there was no one else that they could turn to for such information, making it objectively reasonable for them to engage in a cursory search of the surrounding area of the arrest, including—
So as the Chief Justice asked your colleague, what threat did the Tupperware container pose at this point that allowed them to go continue their search and open the container and so on. What was the issue with waiting for a warrant for that?
Justice, respectfully, it's important to note that the police did not enter the living room with the intention of searching for drugs. However, when they did seize the drugs, they seized it for the reason, and applying the Grant test, the third prong, there was a significant interest in the society's adjudication of the case based on its merits. This drug charge made up 20 months of Mr. Stairs' 26-month sentence in custody, and they seized over.
But the question my colleague asked you is, what justified searching inside the Tupperware? Like, why is that justified? What's the risk posed by the Tupperware, as my colleague asked you? That's the question.
Okay, thank you for your clarification. May I have a moment to consult my notes?
Yeah, totally. Yeah.
Thank you. Justices, I would refer you to paragraphs 165 and 166. I'll answer your question in two parts. First, in referring to paragraph 165, we would note that the trial judge in this case found as a fact that the police acted in good faith at all times during this dynamic arrest and search, believing that their conduct was authorized by law.
But what if they were wrong? That's what we're trying to determine here. Like, how much weight should we place on the fact that they thought they were allowed to conduct themselves in the way that they did?
In our position, the unlawful search and seizure, and this is cited in paragraph 166, my apologies, the unlawful search and seizure was the result of an honest one-off mistake, albeit one with serious implications for Mr. Stairs' right to privacy.
Isn't that a balancing exercise in 24-2, counsel? Even if I accept that finding by the trial judge, if this court is implementing a new test, this court can do its own 24-2 analysis.
Certainly, Justice. And in conducting a section 24-2 analysis, the respondent would concede that the first factor of the Grant test favors exclusion. However, I would note again that the police were acting in good faith at all times, and that this is the first time that this court has considered the search incident to arrest power applied inside a home. With regards to the impact on Mr. Stairs' charter right to privacy, we would also concede that the second Grant factor favors exclusion weakly. Finally, in considering society's interest in the adjudication of the case on its merits, our friends will likely concede, and the lower courts have as well, that the third Grant factor favors the admission of the evidence. We emphasize once again that the police seized over 90 grams of crystal methamphetamine, and that there's a significant public interest in an adjudication of a drug charge on its merits that is as dangerous and as pernicious of a street drug as this one is.
Just adding to what my colleagues, Justice Barkley's comment before, let's just say we give you, going in to look into this rather space in a search incident to arrest, but obviously for the purposes of safety, finding out that the space is safe and secure and seeing something on the floor that either is determined or not as to what it is, why not then secure the area? They now secured the area, get a search warrant. How do you, I mean, there's two steps to it. How do we not say the police should have stopped, which is at the appropriate time, secured the residence, and now sought a search warrant? So how do you get to that leap of the finding of the Tupperware, but then the picking up, looking at it and taking it part of it? Why can't we stop it right there and say the police should have at least gotten a search warrant?
Justice, if I may have a moment to collect my thoughts and consult my notes.
Sure.
Thank you. Justice, we would submit that because this was inadvertent discovery, the officers had every right to seize the drugs in the case at bar.
But how's it inadvertent? They have to look inside. That's a step. That's deliberate.
So it was inadvertent. The plain view part, searching for and seizing the drugs was inadvertent because the police had entered the living room for the purpose of searching for safety risks like other people, assailants, victims, or weapons.
Is that not the crux of this case? I don't think anybody here will argue with you that once the police saw the drugs, they needed to seize them. Is the crux of the case not them going into that next door room?
Justice, if I understand your question correctly, you're asking me if the police should have entered the room?
Isn't that what this is all about?
Yes, Justice, we are submitting that the police had every right to enter the room because after they had concluded they had reasonable suspicion to enter it.
Okay, but tell me why there's reasonable suspicion. What I'm interested to know is, let's say, as Justice Greenspan suggested, they did go get a warrant. Would a justice even grant a warrant in these circumstances?
I'd like to answer your question in two parts. First, as that was not articulated in the case at bar, I am unable to provide an answer to you at this time. However, I would note that the safety search was conducted for weapons, hazards, and other victims or assailants. We would note, as my co-counsel has repeatedly stated, that there were many, many cautions against Mr. Stairs: violence, domestic violence, being a high-risk offender, and an escape risk. Any of these cautions that I've provided could have been assistance could have been provided in the living room to Mr. Stairs for any of these reasons. The mere fact that he was in handcuffs does not diminish the fact that he was an escape risk.
But
How is he
many people who are arrested have criminal records. So are you saying, if you've got a criminal record for violence or a criminal record for obstruct justice or escaping, that's sufficient basis to go ahead and do this kind of search?
No, Justice. What I am submitting, though, is that the officers were acting in an information vacuum. They had very little information and were operating in a manner to best serve the community.
But you're saying two things. You're not saying information vacuum. You're saying there was information. It was his record.
There was very little information, Justice. They only had information of the fact where the car was parked, that there was a domestic assault, and that they had a handful of pieces of knowledge about these cautions and that the victim was not cooperative. They had no reason to, my apologies, they had every reason to search, seeing as all of these facts together provided no aid to them.
Let's say that we're not with you on the fact that the cautions alone are really anything. Was there anything specific? Not just there might have been something. Is there anything specific that you can point us to that could have had them believe that there was actually a risk there?
Yes, Justice. I would refer you to paragraph 91 of the case at bar. As cited in the 1999 case of Regina and Dodd, domestic dispute calls can be dangerous and even life-threatening for officers and persons at the scene. Given the prevalence of domestic violence and its attendant risks, responding police officers must have the ability to assess and control the situation.
I'm sorry, I'm gonna.
My apologies. I don't know if it's just me, but Justice Rivers has cut out or frozen.
We've lost her, Honor.
Okay. I see that my time is elapsing. I'm not sure if anybody would like to continue her question. If not, I would request a brief moment to conclude.
Sure. Chief, should we give Justice Rivers a minute, maybe?
Yes, sure. If she's, hopefully she's back. I'm sure it was a great question. Yeah, I don't know that we have her. Let me see if she's come back. I don't see her. Well, Counsel, go ahead. Oh.
Hi there. I'm just moderating the courtroom. I have noticed that Justice Rivers' power has gone out and she said to proceed without her in the meantime. Thank you.
All right, thank you. Go ahead, Counsel, and why don't you wrap up?
Thank you. Honorable
All right, unless
Justice.
there are any other questions from any of my colleagues.
If I may, Chief Justice.
Yes,
just
yes,
very
absolutely,
quickly.
absolutely.
I'm a little torn on Golub. Are the facts not completely distinguishable here? Because you're saying that they're in an information vacuum. That was not the case in Golub at all.
Justice, I believe that I said it was the case similar to the case of Godoy.
No, that's okay, but I want to know. I want to know. Like, you did rely on Golub a little earlier, and I'm a little hung up on that. Are the facts here not completely distinguishable?
So when I referenced Golub, I said that it was wrong to ignore the realities of the situations in which police officers must make their decisions. That was drawing the line between generalized suspicion and reasonable suspicion, and that's to implore this court to not use, my apologies, to sustain that the police acted on reasonable suspicion as opposed to generalized suspicion.
Okay, thank you, counsel.
No worries. My time is elapsed. May I briefly conclude?
Yes.
Thank you. Justices, while there's no question that one's privacy at home is of value to be preserved and promoted, privacy cannot trump the safety of all members of a household. If our society is to provide an effective means of dealing with domestic violence, it must have a form of crisis response. And for these reasons, we implore the Supreme Court of Lions Cup to dismiss the appeal and uphold the lower court's ruling. Barring any further questions, the respondents rest.
Thank you, counsel.
Thank you.
All right, is there any reply sought?
No, thank you.
I'm sorry, I missed that.
No, thank you.
No, thank you. All right, good. We will then, I guess, retire to consider our decision.
Yes, if all the justices can please make their way to the chambers breakout room. All competitors will stay in this breakout room. Justices, you have up to 15 minutes to deliberate. If you have any questions, just pop back in here and either myself or Jen will assist.
We can go ahead and end the live stream now, please. Thank you.
Sorry, what room do we go to?
Chambers, please. Thanks.
I think I need hosts again to end it.
Can you please provide that to Naomi? Thank you.
You're the host, Jen.